Thank you, Christian. Good evening, ladies and gentlemen, and many thanks for inviting me to speak to you this evening. My opposition to the proposal to abolish corroboration comes as much from my experience prosecuting as it does from my experience defending. Indeed, if anything, possibly more so. The situation we have in this country is that what corroboration means is no one can be convicted on the evidence, a single source of evidence. There must be evidence from two sources. People are very often confused and are indeed, I think, encouraged to be confused by the fact that it is often thought that perhaps corroboration means two eyewitnesses to any particular crime. That is not what corroboration is about. And the best way perhaps of explaining to you what corroboration is explaining to you how at present a rape trial would generally proceed. The evidence in a rape trial in the current climate is normally that of the complainer, the person who claims they have been raped, and there then requires to be corroboration of her evidence. The corroboration for her evidence is found normally, first of all, in scientific evidence establishing that there has been intercourse, but what is then required is some evidence to establish the fact that that took place against her will. That evidence, in the vast majority of cases at present, comes from what we call distress. Distress is the fact that potentially the complainer goes home the next night, the next morning, and is seen to be extremely upset by perhaps a member of her family or a friend or something of that nature. That person's evidence of how the complainer seemed to them is sufficient in law to corroborate her evidence that intercourse took place without her consent. There's no requirement for there to be a third party in the room. There's no requirement for two eyewitnesses. Corroboration is found in facts and circumstances. The law and lawyers, despite what people think, is generally speaking not stupid. And the law in relation to matters of sexual offences has developed over the years in order to take account of the fact that, broadly speaking, this is the kind of crime which takes place in private. The proposal to abolish corroboration, in my opinion, is based on a fallacy that somehow or other abolishing corroboration will result in more convictions in offences of a sexual nature. I cannot understand how even logically that can be the position adopted. At present, as I understand Crown Office statistics, in terms of cases which actually proceed to trial, there are, roughly speaking, 1/3 convicted. Now that means 2/3 are acquitted. Those are in cases where there is some support for the evidence of the complainer, because at the moment you couldn't get the case to court without such evidence. So in cases where there is support for the complainer, there are 2/3 of accused persons being acquitted. What is the logical explanation for why it is thought that if you remove that support, somehow or other that is going to increase the rate of conviction? When Lord Carloway carried out his review, there were certain statistics provided in that review which were based upon two Procurator Fiscals carrying out a certain amount of research, in the course of which they came to the conclusion that, I can't remember the precise numbers, but X number more cases would have been prosecuted. Now, no doubt that is correct. The fact that you have more prosecutions may mean that simply doing the arithmetic, you will add up with, or you will end up rather, with more convictions. But in terms of a percentage, it seems to me, with the greatest of respect, that the likelihood is that the actual percentage rate of convictions will come down. From a prosecutor's standpoint, the law of corroboration is very often the thing which actually gets you over the line so far as a conviction is concerned. As I'm sure we can all imagine, victims of sexual abuse, whether it be rape, whether it be children, whatever, are generally speaking people who are likely to find giving evidence extremely difficult. They are often vulnerable people. They're often understandably nervous and anxious. In those circumstances, and having to stand up in a room perhaps not quite as full as this, but in a room full of, let's say, 20 strangers and tell your story, often means that they come across in a manner which is not terribly convincing. Not through any fault of theirs, but through the fact that they're having to undergo a certain procedure which they're inexperienced in. It is often that small piece of corroboration that enables a prosecutor to go to the jury and to say to them that you may well have not thought that Miss X was particularly impressive in the way that she gave her evidence. However, let's look at this piece of evidence. How is that explained by the accused? And it is very often that piece of evidence which turns somebody who was a nervous, anxious complainer into somebody for whom the prosecution is actually able to achieve the goal and to have a conviction at the end of the day. So corroboration, in my view, is something that is actually beneficial to people in that situation rather than something which hinders them. Yes, it does prevent cases coming to court if there is only one source of evidence, but the law has developed in a way that means that corroboration is not, generally speaking, that difficult to find. And it, in my opinion, abolishing corroboration at this stage is going to be a disservice to victims of sexual abuse, is going to be a disservice to the law of Scotland as it currently stands, and is not going to advance the cause for any of the people who currently speak out in its favour.
That's grand. No, thank you very much. And I'll now ask, because I went about this completely the wrong way, Stephen, if you want to say your piece as solicitor. Can I say, Tony, what's that noise that's going on out there? Radio, folk in the kitchen playing Radio 4? Anyway, it's annoying me. Right. Sorry, Stephen, on you.
Okay. Ladies and gentlemen, thank you very much for the opportunity of my coming along to speak to you this evening. I echo the general sentiments that Ryan's just been explaining to you regarding the abolition of corroboration. You may, ladies and gentlemen, be aware of the background to the Carloway report, which led us on to the bill which is currently being considered by the government. Ladies and gentlemen, that report followed a decision which changed the law in Scotland, the case of Cadar, which changed the position and now allows those suspected of criminal offences access to solicitors and criminal advice before being interviewed by police officers. Now, there was a fear when that decision came into force that the legal advice which would be made available to those persons about to be interviewed would result in fewer people cooperating with police, with a commensurate drop in the rate of successful convictions of crime in Scotland. And it's quite right that a report was commissioned and that consideration was given to that. The difficulty, of course, ladies and gentlemen, is whether we now, some 3 years following that decision, have seen the drop in prosecutions which has been expected. And I have to say that my own recent experience and that of the Edinburgh Bar is that that simply hasn't happened. Over the past 6 months, my understanding is that over 900 additional criminal cases have been marked for prosecution in the Edinburgh area as a set against 2012, and that includes the sort of serious criminal behaviour which the bill seeks to ensure is prosecuted. Within the report, and as Brian was explaining to you, ladies and gentlemen, some 458 cases in 2010 were not prosecuted by the Procurator Fiscal Service due to a lack of corroboration, and the feeling of the author of the report is that some 268 could have proceeded were corroboration abolished. Now that, ladies and gentlemen, is obviously a fairly certain and solid sounding statement, but is it enough to base such a significant change to our law as the abolition of corroboration on? And I would respectfully suggest to you that it's not. Those figures, ladies and gentlemen, were taken from a single year, 2010, and the cases were reviewed by one current Procurator Fiscal and one senior retired Procurator Fiscal. And my understanding is that the work itself and the assessment of those cases took place over some 3 working weeks. 3 working weeks, ladies and gentlemen, with an examination by 2, albeit experienced lawyers, of the figures for a single year. Corroboration has been protecting members of the public and the general civic populace in Scotland for hundreds of years, and in my respectful submission to you, ladies and gentlemen, this is something which requires much more discussion and much more consideration before it can properly be passed into the legislation and law of Scotland.
Thank you very much.
Good evening, ladies and gentlemen. I'll try and keep my voice up. I'm not going to speak for very long. I'm struggling with my voice a little bit, but I'm very grateful for the opportunity of being invited here tonight, because lawyers, I think, are often, perhaps rightly, we're told that we have a self-interest in a lot of the subject matters that we talk about. This is a subject matter that I feel very passionately about, and you might think, well, lawyers are always looking after themselves, but as a solicitor who appears in the criminal courts every day, I should be delighted if there's an abolition of corroboration, because that should automatically result in more prosecutions. But this is something which actually horrifies me, and there's a number of reasons that I can give you for that, and hopefully you'll be left understanding where I'm coming from. The catalyst for this seems to be their perceived low conviction rate in rape cases, and I would suggest that if that is the case, and certainly there's statistics to show that the conviction rate is low, then I would suggest that a change perhaps to public perception or public views is what's required, rather than such a fundamental change to the rules of our system. And when the Justice Minister uses this as an example, or this is a good reason for changing the whole system in Scotland, I wonder, is he saying that the juries in all of these cases were wrong? 15 members of the public, not lawyers. It's not lawyers that make the decisions in these important cases. It's members of the public. And is the Justice Minister saying that the public were wrong in each one of these cases, despite the fact that he didn't hear any of the evidence? I spoke yesterday to a sheriff in one of the jurisdictions in Scotland and told him that I was coming to speak here tonight. And he told me that in the jurisdiction or the court in which he works in Scotland, there are 12 sheriffs. And he said that every one of them are against the abolition of corroboration. So that's sheriffs, not prosecutors, not defence lawyers, not criminals, not politicians, sheriffs who are in the courts every single day. And he also told me what I thought was quite interesting was that, in particular, the sheriffs who had been former prosecutors were the ones who were most vocally against the abolition of corroboration. So I would suggest that that should perhaps tell you something. I agree with Brian when he said that that the members of the public are perhaps being encouraged to be confused about what is required through corroboration. And really very little is required, but it is a safeguard. And I don't know if preaching to the converted here and everybody here knows, but one unexplained fingerprint at a crime scene can be self-corroborating. So we're not dealing with a situation where 2 eyewitnesses to every criminal charge is required before that case even goes into court. I would be the first to agree that that would be completely unworkable and completely preposterous. But what I would ask you to take from what I'm saying tonight is that if corroboration is abolished, where is the protection for you and for me in your everyday life? Where is the protection for an MSP in surgery when somebody perhaps with mental health difficulties makes an allegation, an uncorroborated allegation of anything? It doesn't matter what it is. What about a doctor in their surgery? or a police officer in a cell, me in my office dealing with a client, significantly perhaps a teacher in a school. What are these people to do? Are they to be told, well, just take your chances, that's fine, you'll be cleared after trial? But in these days of enhanced disclosure, are you to just say, well, that's okay, you can just be prosecuted and then acquitted and that'll be fine? But no, it won't. And who decides? There doesn't seem to be any safeguard. I think my understanding is that the fiscals, the prosecution, will take up a prosecution if they take the view that there is a reasonable prospect of conviction. But what is that based on? I can tell you, and you may not realise this, but in most cases, just simply due to the bulk of work and for various other reasons, understaffing or whatever, complainers or victims in criminal cases are generally not interviewed by the prosecution. A police statement is taken from them, the case is reported to the Procurator Fiscal, and the case is either proceeded with or not. So who's going to make the decision as to whether or not the case proceeds? Is it simply to be based on a police report? If that is the case, then that causes me concern, because the police are then having to take on a role of deciding, judge and jury, deciding on the credibility and the reliability of the one witness in a case. And in fairness to the police, that's not escaped their notice, and they're not happy about that. And I would suggest that a system where 22 out of 23 of the most senior judges in this country are not happy about it, almost all of the sheriffs are not happy about it, large number of the police are not happy about it, a large number of prosecutors aren't, defence agents aren't, then I would ask you to consider whether or not, if it was a medical decision, you would simply ignore 95% of surgeons' views when considering whether or not to change medical rules.
Thank you very much.
Thank you very much. I'm pleased to have the opportunity of speaking to you. I noticed from the handout that was issued downstairs before I came up that the three other speakers were all named, plus other senior speakers. So I have to introduce myself as the other senior speakers. I retired about 2.5 years ago, and when I heard of the proposals by Lord Carloway, which look as though they are being supported by the Scottish National Party, I was appalled that the idea of the corroboration should be abolished. It is something that has stood the test of time for centuries, and it is one of the things that we should be very proud of, that the Scottish system is quite separate from other systems, and it is absolutely amazing that the Scottish National Party should, of all people, be supporting the abolition of our unique system of law.
Can I halt you there just to say that, by the sound of this, it isn't the Scottish National Party,
no,
all of us.
I'm very pleased to hear that. Can I just look at this from a slightly different aspect from the other three speakers, with whom, of course, I totally agree? The question that was asked in the reference document was, Lord Carloway concludes that the requirement for corroboration has no place in a modern legal system and should be abolished. Ladies and gentlemen, I think you will find that a most astonishing statement, that the idea that corroboration has no place in any system of law. In England, it is certainly true that the court does not require corroboration. But in England, the judges are much more active in taking away from juries cases where they think that the verdict would not be supportable. And we do not have that power, and Lord Carloway is, in particular, as I understand it, is not allowing the judges to take cases away because he thinks that the judge may think it's unsafe, which is the English term. Ladies and gentlemen, in any trial in England, the prosecution will normally produce additional witnesses to support the complainer. In rape cases, of course, the complainer is the lady who comes along and says that she has been raped. And it is a entirely unsatisfactory system that we should ask juries to believe one person against another, the woman as against the man. As I'm sure you all know, some people are much better at expressing themselves than others. And so the person who is most eloquent in stating his position, the man, that it was all with consent, or the woman that it wasn't with consent, are we really going to result in people being sent to prison for long periods of time just on the basis that we think the girl is actually a better speaker than the man? And so it's very important that that is looked at. One other matter that I think is quite important and we can learn from the English system is the terms of the caution which is administered to accused persons. In Scotland, accused persons are people who are suspected of committing a crime are told that if they're not obliged to say anything, but if they say anything, it will be taken down and may be used in evidence. The English system, and it is a statutory provision under the PACE Act in England, you do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. Now, one of the problems in rape cases is that the accused, perhaps on the advice of his solicitor, will say nothing when he's told that he doesn't have to say anything, but if he does, it may be taken down and founded upon. In England, the persons accused, particularly of serious crimes like rape, cannot come along at a later stage and say, oh, but it was consensual. Because if they hadn't said that when they were first charged by the police, then in terms of the caution which is administered in England, that will rebound against them. And I suggest that that is one aspect, one way that can be cured the problems that the Cadder case has resulted in. In England, juries, of course, are required to be unanimous. First, the judge will ask the jury to consider their verdict, and they must be unanimous. If they take a long time to consider it and haven't reached a verdict, he may allow them to reduce the majority to 10-2. It's a long way from our system, which I appreciate there may be proposals to change the majority, but in Scotland we are prepared to convict people on the basis of 8 in favour and 7 against. That's one person makes the difference. And it is therefore all the more important that in making that decision, they do so on the basis of corroborated evidence, and it is only the question of credibility and reliability that they have to consider. For all these reasons, and for all the reasons that have been more eloquently expressed by my colleagues, I suggest that this should never happen.
Now, I'm going to open it to the floor, so if you just, I know you're not shy, so if you just stand up and say your name, and if you want to put your question to a particular member,